Resources on harassment. Your company should have several resources available to employees for learning about, responding to, and preventing harassment of all types. Your company should have an anti-harassment policy and prevention program in place. This document should be made available to every employee. Included with this training is a sample of what that kind of policy could look like. This policy will explain who to report a complaint to, what the expectations are for employee conduct, and offer information on the complaint, investigation, and follow-up process. Another resource is the Discrimination and Harassment in Employment poster, which should be posted at every office location. This specifies the types of harassment which are illegal in California and the laws that employers must follow. Also provided should be an information page which talks about the employer's obligation to provide a safe and respectful place to work and instructions on how to file a complaint. Your company may have additional training programs or awareness materials to help sensitize employees to the issue of harassment. There are also several outside resources, organizations, websites, books, and more to help support the victims of harassment. Let's talk about liability. The employer can be held liable for harassment complaints when they know about the misconduct but don't respond. They know about the misconduct and respond, but it's ineffective. Or they don't know about the misconduct and don't respond. And other scenarios as well. If the harassment is minor and the change in work conditions is only a threat, meaning no actual changes are created, then limited liability still exists. The good news is that the employer can also prevent liability. An employer might avoid or reduce liability if the alleged harasser is not in a position of authority. The employer had no knowledge of the harassment, or in other words, no one reported it. If, once aware of the harassment, the employer takes immediate and appropriate corrective action to stop it. And if a prevention program to prevent harassment is in place. Let's look at strategies beyond just policies and procedures. The best remedy for sexual harassment is prevention. The best prevention method is a zero-tolerance stance. If harassment occurs, prompt action should be taken to stop it. A program to eliminate sexual harassment from the workplace is not only required by law, but it is the most practical way for an employer to avoid or limit liability if harassment should occur despite preventative efforts. Your company's harassment program should address preventative measures to help maintain a safe and respectful work environment. This program may include offering training to employees, increasing awareness through educational materials and other resources. These administrative processes set the standard, but as the supervisor, you become a practical example, demonstrating to others the behaviors expected of them. By displaying your company's values, discussing harassment issues with employees, and handling claims professionally. Your company may already have its own set of values and a code of conduct to help supervisors perform these important functions, but the California Government Code 12590.1 requires training on specific values for effectively managing sexual and other harassment in the workplace. Today we'll give you 3. First, treat all victims of sexual harassment with dignity, fairness, and respect. Treat every reported incident seriously and follow proper guidelines. Every claim gets a thorough and objective investigation. Treat all information related to the claim as confidential to be shared on a business need-to-know only. Each of these values should be maintained whether on or off duty. This means not discussing events over happy hour or with your family members. Just imagine if the situation involved you or one of your close friends or family members. You wouldn't want their private situation discussed by people who have no business knowing. In many ways, what we've already talked about could be applied to all other types of harassment. It's not to be tolerated. It's destructive, and the company is responsible for preventing it. Let's look into other types of harassment prohibited in California so you can recognize it and do something about it. Racial harassment involves discriminating conduct based on a person's race or because of certain physical characteristics associated with that race. This could include someone's hair color or texture, skin color, nose or eye shape. Included could be their accent or pattern of speech, which may also fall under national origin. In addition, physical or medical conditions characteristic to certain races is also included. Harassment could even occur because someone is married to or otherwise associated with a person of a certain race, or has a connection to an organization that is generally associated with people of a certain race. Common forms of harassment include racial slurs, offhand comments about a racial group or an individual's race, or the display of racially offensive symbols. Color discrimination. The laws do not define color, but courts and the Equal Employment Opportunity Commission commonly understand color to mean pigmentation, complexion, skin shade, or tone. This means the lightness, darkness, and other color characteristics of the person's skin. Even though race and color clearly overlap, they're not the same. Thus, color discrimination can occur between persons of different races or ethnicities, or between persons of the same race or ethnicity. Another category that overlaps is genetic information. This could include many more areas than we are even able to address within this training. Physical features such as eye or hair color, skin appearance, dominant hand use, and physical build are just a few of the genetic features that could become the base for discrimination. Age discrimination could be based on one's perceived or actual biological age. Skin quality, hair color, stature, speech, and other physical characteristics are usually the easiest identifiers of age, and therefore are often the base of harassment and discrimination. A fact check is necessary to determine the actual work performance and qualifications of the individual. Employers are also required to make reasonable accommodations, such as job adjustments, schedule flexibility, and more, unless to do so would create an undue hardship on the business. Religious discrimination involves treating a person unfavorably because of his or her religious beliefs. The law protects not only people who belong to traditional, organized religions, such as Buddhism, Christianity, Hinduism, Islam, and Judaism, but also others who have sincerely held religious, ethical, or moral beliefs. Religious discrimination can also involve treating someone differently because that person is married to or associated with an individual of a particular religion, or because of his or her connection with a religious organization or group. Employers are required to reasonably accommodate an employee's religious beliefs or practices, including their dress, grooming, and schedule assignments, unless doing so would cause an undue hardship on the employer, such as increasing costs, compromising workplace safety, decreasing work efficiency, infringing on the rights of other employees, or requiring other employees to do more than their share of potentially hazardous or burdensome work. National origin discrimination involves treating people, applicants, or employees unfavorably because they are from a particular country or part of the world, because of ethnicity or accent, or because they appear to be of a certain ethnic background, even if they're not. This can also involve discrimination when someone is married to or associated with someone in connection to an ethnic organization or group. Employers are not permitted to prohibit the use of a language unless doing so would cause an undue hardship or if fluency of a specific language is necessary to perform the job safely, effectively, and efficiently. Discrimination based on accent is also not permitted unless the accent seriously interferes with the employee's job performance. These same principles apply to ancestry discrimination, although ancestry also includes your family's historical origin, ethnicity, and more. Discrimination based on gender and the identity or expression thereof is included as sex discrimination, but in California is specifically protected. Transgenders, transsexuals, and cross-dressers are protected under this law. The Equal Employment Opportunity Commission ruled sex discrimination to include treating an employee differently for conforming or not conforming with any gender-based expectations or norms. Best practices to help prevent discrimination in this area include a gender-neutral dress code, being sensitive to the use of pronouns in written materials, and providing regular harassment training to all employees. Sexual orientation discrimination can occur based on one's perceived or actual sexual orientation, whether they're gay, lesbian, bisexual, or heterosexual. Dress, behaviors, parenting styles, and other personal choices are often the subject of harassment. This category falls under sex discrimination, but in California is also protected individually, like gender identity. Marital status discrimination involves unfavorable conduct towards or favoring of employment conditions, benefits, or privileges based on one's marital status. This often includes exercise of parenting rights, the use of medical or pregnancy leave, participation with work-related events, or travel and schedule flexibility. Hiring practices are another frequent event associated with marital status discrimination. For jobs requiring frequent or long-term travel, some employers seek unmarried applicants, assuming that they will have more flexibility with their schedules and could potentially have less need for accommodations. In a job that is highly dangerous, an unmarried candidate might also be considered over married ones with dependents. Both of these practices are illegal. Those who are protected under disability discrimination laws include persons with physical or mental impairments which substantially limits one or more major life activities, or has a record of such impairment, or is regarded as having a disability. These facts cannot be a deciding factor for work conditions or privileges. What outweighs this perceived or actual limitation is found through a fact check. An individual is considered qualified to work if he or she satisfies skill, experience, education, and other job-related requirements of the position held or desired, and who, with or without reasonable accommodation, can perform the essential functions of the position. Employers are required to reasonably accommodate an employee's abilities, such as through adjusted workspaces, acquiring modified equipment, or assisting with training or material comprehension, unless doing so would cause an undue hardship on the employer, such as increasing cost, compromising workplace safety, decreasing work efficiency, or infringing on the right of other employees, or requiring other employees to do more than their share of potentially hazardous or burdensome work. Discrimination based on medical conditions, both new and pre-existing, is also not allowed. This is true even if someone has an identifiable gene or chromosome or an inherited characteristic known to cause or increase the statistical risk of a particular disease or disorder that presently does not have symptoms. This would be like being HIV positive but not actually having AIDS and being harassed or discriminated against for the possibility that you could. If you qualify for family or medical leave, you have the right to take that leave free from harassment or discrimination. Employees have the right to take up to 12 weeks of unpaid leave per year for the following reasons: for your own serious health conditions which keeps you from doing your job, to care for a sick child, spouse, or parent with a serious health condition, or to care for a newborn child, newly adopted child, or foster child. A serious health condition is an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential medical care facility, or which involves continuing treatment by a healthcare provider. Check with your employer to learn more about the qualifying period which determines when you're eligible to use the leave. The same discrimination rules apply to the use of pregnancy leave. During leave, employees have the right to the same or equivalent position unless it was eliminated for legitimate business purposes not related to the use of leave. While on leave, employees are entitled to maintain their medical benefits, and they cannot lose any employment benefits. The bottom line is that there is a none, nada, zip, zilch, and zero tolerance stance for harassment. If you are a victim of, a passerby, a coworker, a supervisor, or somehow come to know or hear about harassment happening in your workplace, please report it and do something about it. Tell your supervisor, your human resource department, your safety department, or your local EEOC. When employees don't respect each other, the company can expect resistance, hostility, lowered morale, and lowered productivity. The primary goal of the anti-harassment policies and programming is not simply compliance with discrimination laws. They are designed to promote a respectful, inclusive, and productive environment for all employees. This goes beyond the law. Organizations can achieve this by valuing and supporting the differences of employees. When employees feel respected, valued, and included, they are happier and more effective at their jobs. Remember, the best method for addressing harassment in the workplace is to actually do something about it. We all share this responsibility. This makes you certainly the most important element of creating a respectful, safe, and harassment-free place to work. Thanks again for joining us for this course. As a reminder, before you leave, please download all the supporting materials. Thank you.